Dear students, viewers and the subscribers, welcome to the IAS Mentor. You are watching the series Indian Polity and you are watching lecture number 93. And recently we have started the new topic, that is the Indian judiciary. In the Indian judiciary, we have already covered the basics as to what is the structure of the judicial system in our country. And at the apex, we have got the Supreme Court of India. And below the Supreme Court, you have got the High Courts. And then below the High Courts, you have got the various subordinate courts. And how the appointment happens to the Supreme Court, what does it mean by the collegium system, what are the criticism of the collegium system. So these are all some of the things that you have learned in our previous lecture. In today's lecture, what we will specifically learn is what are the various powers and jurisdiction of the Supreme Court. By that, what do I mean? That what are the various types of cases that can be entertained by the Supreme Court? And what are the various orders that can be passed by the Supreme Court of India? And to that extent, the Constitution itself is providing specific provisions relating to the jurisdiction and powers of the Supreme Court. Very, very important area. In most of the year, UPSC has asked question from this particular topic. So therefore, it is very important for us to have a keen understanding as to what are the various jurisdiction and the powers of Supreme Court of India. Alright, so let us move and let us study them one by one. As I already said, one of the important objective of this particular series is to provide a comprehensive idea to the students preparing for various competitive examination with regard to the subject Indian polity. Alright, so let us move forward. Let us try to understand as to what are the various jurisdiction and powers in the hands of Supreme Court of India. If you see various jurisdiction and powers in the hands of Supreme Court of India, so basically these are all the various jurisdiction. They have original jurisdiction, they have writ jurisdiction, they have appellate jurisdiction, they have appeal by special leave jurisdiction or special leave petition jurisdiction, advisory jurisdiction, and apart from that they have number of powers like review powers, contempt powers, extraordinary powers under Article 142 of the Constitution, and apart from that they have rule making power, and they also have what is the power of being the apex court, that is law declared by the Supreme Court to be binding upon all the courts. Okay, so these are all the major jurisdiction and the powers that is exercised by the Supreme Court of India. But as we'll proceed, we'll try to understand them one by one as to what they are, what are these powers, what are the nature of these powers, how these powers are exercised. Very important, any of these things may be asked in the prelims examination. So the first thing that you are going to understand is what is called as original jurisdiction. To put it in a very simple way, what is original jurisdiction? These are all cases that you can directly go to the Supreme Court. Directly, and it is not only directly and only to the Supreme Court. No other court can entertain these petitions. What is the only court that is capable of entertaining such disputes or the petitions is only the Supreme Court of India. And such cases shall be entertained only by the Supreme Court because only the Supreme Court has got original jurisdiction with regard to these disputes. So what are those disputes? Who are the parties who can go to the Supreme Court of India under the original jurisdiction of the court? Try to keep it very simple. In what type of cases the Supreme Court has got original jurisdiction is in case of what is called as federal disputes. The word federal dispute is very, very important. So who are the parties who can approach the Supreme Court of India under the original jurisdiction if they are part of the federal relationship? And in case of federal disputes, they can approach the Supreme Court of India under their original jurisdiction. That means directly and only to the Supreme Court. In fact, the original jurisdiction is also the exclusive power of the Supreme Court. That means no other court has a power to entertain such cases directly. And who is the only court to entertain such cases directly? Only the Supreme Court. So I said that it should be a federal dispute. Federal dispute means any dispute that is arising between the federal components of our country or the federal units of our country. So what are all considered to be the federal units of the country? Any dispute that is arising between the center versus the state. That is any dispute between a central government and that of any state government. Any dispute between state government versus state government. Any dispute between center and some of the states on one side and the other states on the other side. In all these cases, they are all considered to be what is called as the federal disputes. So therefore, to keep it very short, what is a federal dispute? The dispute that is arising between the federal units of a country. So these are all considered to be what is called as the federal disputes. And whenever there is a federal disputes, say for example, if there is dispute between the central government and the state government on a certain matter, the case cannot go to any of the high courts in our country. The case can be filed only in the Supreme Court. Similarly, if there is a dispute between two governments, say let us assume there is a dispute between state of, let us assume Maharashtra, and let us assume state of Gujarat, for example. Then in that particular case, the dispute cannot go to the High Court of Gujarat also, High Court of Bombay also, but it has to go only to the Supreme Court of India. So therefore, when it comes to any federal dispute, the dispute can be taken up only by the Supreme Court of India. Okay, now let me put another question. What if there is a dispute between Union Territory and the Union Government? So for example, National Capital Territory of Delhi, that's a Union Territory. And what if there is a dispute between National Capital Territory of Delhi and the Union Government? Will it go to the Supreme Court directly under the original jurisdiction? In this case, it will not go to the Supreme Court of India directly because the National Capital Territory of Delhi and the Union Government is not in a federal relationship, because the Union Territories are considered to be part of the Union. The Union Territories are to be administered by the Union itself by virtue of Article 239 of the Constitution. Although some of the Union Territories, including Delhi, may have a special status, but that doesn't mean that Delhi is a state. So only the states are in a federal relationship with the Union Government. So therefore, if there is any dispute between the Union Government and an Union Territory, the dispute shall first go to the appropriate high courts. Say for example, in case of Delhi, they have their own high court. So therefore, the dispute will go only to the high court. And by a way of an appeal, if the matter is not resolved, then they can go to the Supreme Court. So they may fall under the appellate jurisdiction of the Supreme Court, not under the original jurisdiction. So what are the cases in which the dispute shall lie in front of the Supreme Court under its original jurisdiction? That is, in case of dispute between the center versus a state, center and some of the states on one side, the other states on the other side, state versus state, some of the states on one side, some of the states on the other side. In all these cases, the dispute falls under the original jurisdiction of the Supreme Court. So I hope this is clear to all of you. But however, if there is a dispute between an Union Territory and an Union, the dispute shall not lie under the original jurisdiction. But however, if there is a dispute between Union Territory and a state, suppose example, tomorrow there is a dispute between National Capital Territory of Delhi and Punjab, or say for that matter Uttar Pradesh, or for that matter Haryana, let us assume, because Delhi is surrounded by Haryana and Uttar Pradesh. So if there is some dispute, let us assume, in that particular case, the dispute between a National Capital Territory of Delhi, which is an Union Territory, and the state falls under the federal dispute. So therefore, it will go to the Supreme Court of India directly, because the National Capital Territory of Delhi is considered to be the Union. It is part of the Union Government. So therefore, it will go to the Supreme Court. So try to have an understanding about all these things very keenly. But however, there are few exceptions to this. What are the exceptions to this? The exception to this is that even though that there are federal dispute which shall normally go to the Supreme Court, but in one particular federal dispute, say for example interstate river water disputes, you might have heard of interstate river water disputes. I am sure that most of you might have heard of interstate river water disputes, that is dispute between two or more states with regard to sharing of the river water. Say for example, there is a river water dispute between state of Tamil Nadu and Karnataka with regard to sharing of the Kaveri river water. So whenever there is an interstate river water dispute, can this dispute go to the Supreme Court under the original jurisdiction? One exception that is given in the Constitution is in case of interstate river water disputes, although it is a federal dispute, no doubt, although it is a federal dispute, this dispute shall not go to the Supreme Court of India directly, or this dispute shall not fall under the original jurisdiction of the Supreme Court under Article 131 of the Constitution. No. They will not be falling under the original jurisdiction. So this is exactly what we will have to understand. So be very clear, under Article 131 of the Constitution, this shall not fall under the original jurisdiction. Why? Because there is a specific article which is called as Article 262 of the Constitution. Now what is Article 262 of the Constitution is saying? Article 262 of the Constitution is saying, in case if there is any federal dispute, that is, if there is a dispute between the center and the state, or if there is any federal dispute which is related to the interstate river water dispute. So basically an interstate river water dispute is only between the two states. So therefore, make it very clear, let me just explain it again. If there is any interstate river water disputes, in case of an interstate river water disputes, such disputes shall not fall under the original jurisdiction of the Supreme Court, but rather such dispute shall go only in front of an authority, or such dispute shall be challenged only in front of such an authority as may be established by an act of parliament. So under Article 262 of the Constitution, the parliament shall have the power. Who shall have the power? The parliament shall have the power, and based on the law made by the parliament, they shall establish an authority, and only in front of such an authority the interstate river water dispute shall be challenged. So this is what the law says, or this is what the Constitution says. Accordingly, the Parliament has already enacted what is called as the Interstate River Water Disputes Act. Interstate River Water Disputes Act 1956. Disputes Act 1956. So therefore, any dispute between the states in case of interstate river water dispute, it does not fall under the original jurisdiction of the Supreme Court. And where does it go? It goes to a tribunal which is established under the Interstate River Water Disputes Act. So for example, under the Interstate River Water Disputes Act, the Kaveri River Water Tribunal was established for dispute between the state of Tamil Nadu and Karnataka with regard to the sharing of river waters. So therefore, in general, what is Article 131 of the Constitution is saying? It is talking about the original jurisdiction. So in case of any federal dispute, the dispute shall go only where? The dispute shall go only to the Supreme Court of India. But however, one exception to such federal dispute is in case of what is called as interstate river water disputes. In case of interstate river water disputes, the dispute shall lie only in front of such an authority as may be established by an act of parliament. Alright. So this is with regard to the original jurisdiction. So now we will move to what is called as the writ jurisdiction. So what is this writ jurisdiction? Writ jurisdiction is the jurisdiction of the Supreme Court, where the Supreme Court is going to entertain only those cases which is related to the violation of the fundamental rights. So if at all the fundamental rights are violated, then the citizens can approach the Supreme Court of India directly. But what shall be the nature of cases? The nature of cases is violation of the fundamental rights. And when the fundamental rights are violated, the affected individuals can approach the Supreme Court, and the Supreme Court can issue writs under Article 32 of the Constitution to protect the fundamental rights. And we know that under Article 32, the Supreme Court can issue 5 types of writs. That is writ of habeas corpus, writ of mandamus, writ of prohibition, writ of certiorari, and the writ of quo warranto. So these are the 5 types of writs that can be issued by the Supreme Court. And we have already elaborately discussed all these 5 types of writs. The writ of habeas corpus is basically to have the body. The writ of mandamus is the court commands a particular authority to perform their duty. The writ of prohibition is to forbid or to stay an order of a lower court. The writ of certiorari is to certify an order of lower court. And then the last thing is writ of quo warranto is by what authority or by what warrant somebody is holding on to a public office. And in fact, we have tried to deal with this elaborately in the topic of fundamental rights. So the students who are watching this, if you have any questions with regard to these writs that is issued by the Supreme Court of India, you can go to the lectures related to the fundamental rights where I have discussed about the various writs that is issued by the Supreme Court. You can watch that particular lecture. But anyways here, so whenever there is a violation of fundamental rights, where they can go to the Supreme Court of India and they can file this particular case. And is it possible for the Supreme Court of India to issue writs for any of the other rights apart from fundamental rights? No. The Constitution only gives the power to the Supreme Court to issue writs only for the violation of fundamental rights and not for any of the other rights. But however, you should also be aware of Article 139 in the Constitution. What is Article 139 of the Constitution is saying? Article 139 of the Constitution is giving the power to the Parliament to make a law, and by that law to empower the Supreme Court of India to issue writs even for the protection of the legal rights. But however, till this point of time, no such law has been made. So in the future, if the Parliament wants to make a law, they can very well make a law, and by that law they can empower the Supreme Court of India to issue writs even for the protection of legal rights, but as of now we do not have any such law. So therefore the Supreme Court of India today is empowered to protect only the fundamental rights, for which they can issue writs directly under Article 32 of the Constitution. So in case of writ jurisdiction, only where the violation of fundamental right is violated, there you can move to the Supreme Court of India directly. And then the Supreme Court of India has also what is called as appellate jurisdiction. So what does it mean by an appellate jurisdiction? Appellate jurisdiction is by a way of an appeal. So that is basically what is called as appellate jurisdiction. What do you mean by way of an appeal? By a way of an appeal means you are not going to the Supreme Court directly, but after the judgment is passed by the High Court, and if you are not happy with that particular judgment, you are making an appeal to what is called as the Supreme Court of India, and thereby you are going to the Supreme Court of India by a way of an appeal. So that's basically what is called as appellate jurisdiction. What are all the areas on which there is an appellate jurisdiction? In all the civil and criminal matters. See, in case of civil disputes or in case of criminal disputes, of course we cannot directly go to the Supreme Court, because as an individual we can directly go to the Supreme Court only in case of violation of the fundamental rights. So in civil and criminal cases there is no violation of fundamental rights, it's our ordinary legal rights are getting violated. So when our ordinary legal rights getting violated because of the criminal and civil cases, now in that particular case we will not be able to go to the Supreme Court of India directly, but rather we can go to the subordinate courts or we can go to the high courts. And if you are not happy with the judgment which is given by the high courts on these matters, and then by a way of an appeal we can make it to the Supreme Court of India under the appellate jurisdiction of the Supreme Court. So the appellate jurisdiction of the Supreme Court is open to all the civil and criminal matters, provided you want to make an appeal from the High Court. So this is basically what is called as appellate jurisdiction. Very, very important. There are a few more things I'll explain as I'll proceed, but before we understand that, let us go to what is called as the appeal by special leave or the special leave jurisdiction, or it is also called as a special leave petitions which is filed under the special leave jurisdiction. In fact, very, very important jurisdiction under Article 136 of the Constitution. In fact, the special leave jurisdiction is also considered to be extraordinary jurisdiction in the hands of the Supreme Court. Now, why the special leave jurisdiction is considered to be an extraordinary jurisdiction in the hands of the Supreme Court? It is considered to be an extraordinary jurisdiction in the hands of the Supreme Court because under this particular article, that is Article 136 of the Constitution, nothing prevents the Supreme Court from entertaining any type of cases in front of it. Nothing in this article or nothing in any of the provisions in the Constitution shall prevent the Supreme Court of India from entertaining any type of case. That is what is Article 136. Say for example, now let us try to relate. We have already seen what is Article 262. What is Article 262 saying? Article 262 saying in case of interstate river water disputes, any interstate disputes in case of river waters. So whenever there is an interstate river water dispute, then in that particular case, although it is a federal dispute, no doubt, the matter cannot directly go to the Supreme Court. And because the matter cannot directly go to the Supreme Court in case of interstate river water dispute, the Constitution is saying, so where such disputes can go, such disputes can be placed only in front of such an authority as may be determined by an act of Parliament. So the Parliament can make a law, and by that law they can decide an authority in front of which such a dispute may lie. So this is basically what you'll have to understand. And this is basically what is how an interstate river water disputes can be challenged. And accordingly, the Parliament has already enacted a law, that is the Interstate River Water Disputes Act. Under the Interstate River Water Disputes Act, they can establish various tribunals. Ad hoc river water tribunals. Ad hoc tribunals are temporary tribunals where the disputes can be taken up. But however, of late do you know that the Kaveri River Water Tribunal took almost 28 years to pass an order because of the dispute between the state of Tamil Nadu and the state of Karnataka with regard to the river water disputes. But however, despite the order was passed by the River Water Tribunal, that is the Kaveri River Water Tribunal, the Karnataka government has shown non-compliance with these orders. And because they have shown non-compliance with these orders, then the Tamil Nadu government has made an appeal against this particular order. So where they have gone for this appeal against the order, they have gone for an appeal in the Supreme Court of India. But however, try to understand the Constitution of India under Article 262 of the Constitution prohibits to go to the Supreme Court of India in case of an interstate river water disputes. So therefore, where and how the Tamil Nadu government was able to go to the Supreme Court is by way of what is called as filing a petition under the special leave jurisdiction. So what is a special leave jurisdiction? So special leave jurisdiction is saying that even if you cannot go to the Supreme Court as per the Constitution or under any of the other provisions in the Constitution, nothing prevents an aggrieved party to go in front of the Supreme Court and make a special prayer in front of the Supreme Court. And if the prayer is accepted, that means prayer is accepted means leave is granted. That means the Supreme Court is accepting this particular matter. And if the Supreme Court accepts this particular matter, then the Supreme Court can hear this particular matter under what is called as a special leave jurisdiction. So what is special leave jurisdiction? If anybody is not able to go to the Supreme Court under any of the jurisdiction, but still nothing prevents them from going and making a prayer in front of the Supreme Court under what is called as a special leave jurisdiction. So this is basically what you'll have to understand with regard to the special leave jurisdiction. So that is why it is considered to be an extraordinary power in the hands or extraordinary jurisdiction in the hands of the Supreme Court. In fact, the Supreme Court itself has said in number of cases that this power has to be very sparingly used because it's an extraordinary power. So the Karnataka government, against which the Tamil Nadu government has now gone to the Supreme Court, they have made a SLP petition in the Supreme Court and the leave has been granted. So this is basically what you'll have to understand. The only exception with regard to the special leave jurisdiction, which is mentioned in the Constitution itself, as to what type of cases shall not be entertained by the Supreme Court, is if a case is related to what is called as Armed Forces Tribunal, or if a case is related to the court martial. If a case has been brought into it through court martial, then in that particular case, it is not possible. So this is exactly what you'll have to understand with regard to the appeal by special leave. All right, so let us just move to the next topic, that is the advisory jurisdiction of the Supreme Court. Now, what does it mean by the advisory jurisdiction of the Supreme Court? So it has to be very clear in your mind when we talk of the advisory jurisdiction. So the advisory jurisdiction of the Supreme Court states that whenever there is any question of law or any question of fact where the President is not having the clarity on this particular matter related to the provisions of the Constitution or relating to the provision of any fact, in such a case, the President can refer this matter to the Supreme Court of India under the Constitution. And which article empowers the President to refer this particular matter to the President is Article 143 of the Constitution. So under Article 143 of the Constitution, the President can refer this matter, be it a matter related to interpretation of the Constitution, be it a matter related to what is called as a question of fact. Under such a circumstances, the President may refer this particular matter. But however, you'll have to understand two important things. One, that whether the matter that is referred by the President is related to a pre-constitutional agreement or a treaty that has happened before the commencement of the Constitution or subsequent to the commencement of the Constitution or something related to the Constitution. So if the matter that the President is referring is related to a pre-constitutional matter, let us assume a pre-constitutional treaty, because the government of India before the commencement of Constitution has also entered into a number of agreements. So if any clarity is sought which is related to a pre-constitutional matter, in that particular case, whenever the President refers this matter to the Supreme Court of India, it is mandatory for the Supreme Court of India to give its opinion. So the Supreme Court shall give its opinion. But whereas if whatever the President is referring is not a pre-constitutional matter, but it is related to a post-constitutional matter, it can be anything. A post-constitutional matter can be related to what is called as interpretation of the Constitution, or it can be a question of fact. It is not even related to the Constitution, it is related to a question of fact. It may be related to interpretation of law. So in all these cases, if it is related to a post-constitutional matter, then in that particular case, it is not mandatory for the Supreme Court to give its opinion. The Supreme Court may give its opinion or may not give its opinion. But however, in both the cases, be it a pre-constitutional matter or be it a post-constitutional matter, in both the cases, if the opinion is given by the Supreme Court, the opinion given by the Supreme Court is not binding on the President. It is not binding on what? It is not binding on the President of India. So this is what basically you'll have to understand. But generally remember why such an opinion is sought from the from the Supreme Court of India, because the government does not know how to act on a particular matter. Therefore, the opinion is sought. So in such a cases, please understand, normally whenever an opinion is sought and when the opinion is given, so normally they act in accordance with such opinion given by the Supreme Court. Say for example, Re-Birubari Union case in 1960 was a presidential reference. Keshav Singh in 1963 was a presidential reference. Third judge's case in 1998 was a presidential reference. These are all at least some of the examples of where the presidential reference was made under Article 143 to seek some clarification on the matter related to the interpretation of the Constitution, and such opinion was followed by the government. So try to understand, this is basically what is Article 143 of the Constitution, and to that extent it empowers the President of India to seek an opinion from the Supreme Court of India. So the next thing is what is called as contempt powers. Now what do you understand by contempt powers? We know that under the Constitution, the Supreme Court is also court of record. That means whatever is happening in the Supreme Court, they are all recorded for official purpose, and whatever judgment that is passed, that is also recorded, and all these things may have, whatever proceedings in the Supreme Court may have what is called as an evidentiary value in the in anywhere it can be produced. So therefore, whatever order that is passed by the Supreme Court cannot be questioned in other places. They have to accept it as an evidentiary value. If it is not accepted, or if there is any non-compliance with the orders that is passed by the court, then that can also be seen as what is called as contempt of the court. And the Supreme Court of India also exercises contempt powers under Article 129 of the Constitution. So basically contempt means a form of disrespect to the authority of the court. If anybody is showing disrespect to the authority of the court, then the Supreme Court of India shall have the power to punish them under Article 129 of the Constitution. But however, what is contempt is not defined in the Constitution, and what is a punishment that shall be given for the contempt is also not defined in the Constitution, or it is not prescribed in the Constitution. The Constitution only gives the power to the Parliament to make a law in this particular regard, because contempt of court. So contempt of court is a subject matter on the Union list in the Schedule 7 of the Constitution, and because it is there in the Union list, who will have the power to make laws on contempt of the court? It is a Parliament that will have the power to make laws with regard to contempt of court. So the Parliament has already enacted a law which is called as the Contempt of Court Act 1971. And if you read this Contempt of Court Act 1971, which prescribes two forms of contempt which can happen against the Supreme Court. One is the civil contempt, and another is the criminal contempt. So generally have an understanding, civil is a mild form of contempt where people are showing, or an authority is showing, non-compliance to the authority of the court. But whereas a criminal contempt is a major contempt. When I say criminal contempt is a major contempt, in case of a criminal contempt, the court can provide for imprisonment also, where somebody is trying to prevent the court from administering justice, or somebody is bringing disrepute to the court. So in all these cases, it can be considered to be what is called as criminal contempt, for which even imprisonment can be awarded by the court. So this is basically what is called as criminal contempt. So therefore, try to understand, the Supreme Court of India is having contempt powers by virtue of Article 129 of the Constitution, and basically the court can punish for both civil as well as criminal contempt. But what is contempt is not defined in the Constitution. It is only the law made by the Parliament, that is the Contempt of Court Act, defines contempt into civil as well as criminal contempt. I hope this is clear to all of you with regard to what is the contempt powers. And apart from that, the Supreme Court of India also has what is called as extraordinary powers. Earlier we have discussed about the extraordinary jurisdiction of the Supreme Court. So what is this extraordinary jurisdiction of the Supreme Court? We have seen about the extraordinary jurisdiction of the Supreme Court under Article 136 of the Constitution. And what is this extraordinary jurisdiction of the Supreme Court under Article 136? If you see the extraordinary jurisdiction of the Supreme Court under Article 136, they have the power to what is called as to accept any type of petitions which shall not be entertained by other jurisdiction. But however, when you talk of the extraordinary power in the hands of the Supreme Court, when we say the extraordinary power, which means nothing which is presented in an ordinary law shall not prevent the Supreme Court of India from entertaining what is called as complete justice or ensuring complete justice to the victim. Or in other words, the ordinary law of the land cannot constrain the Supreme Court of India in ensuring complete justice, cannot prevent the Supreme Court of India in ensuring complete justice on a particular matter. So, for example, recently I came across a news where there was a minor girl who was a victim of crime of rape, and then subsequently she became pregnant because of the rape. But however, she was not aware that she was not raped, and then when she was aware of rape, that it was more than 24 weeks of pregnancy. And then the girl has sought medical termination of pregnancy, where the doctors did not do it because it is not their fault. Because as per the Medical Termination of Pregnancy Act, the pregnancy can be terminated only up to 24 weeks. Normally up to 20 weeks it can be terminated, but in special cases it may extend up to 24 weeks if the doctors certify that yes, in the interest of the mother health or in the interest of the child, it has to be done. But in this case there was nothing of that particular sort, so therefore the doctors were not ready to terminate the pregnancy. Then subsequently the girl has moved to the Supreme Court of India, where the Supreme Court of India has passed orders to terminate the pregnancy. So therefore try to understand what is this extraordinary power in the hands of the Supreme Court. Nothing will prevent the Supreme Court of India in ensuring complete justice to a victim in a particular case, even if it is going beyond the law established by the Parliament or the law established by the state legislature. So this is basically what you'll have to understand with regard to the extraordinary power in the hands of the Supreme Court. Very, very important topic. Many times has been asked in the examination. And this extraordinary power of the Supreme Court comes from Article 142 of the Constitution. So which is giving this power to the Supreme Court? Article 142. Apart from that, law declared by the Supreme Court is binding upon all courts. We already seen that the judiciary in India is an integrated judiciary, which is under Article 141 of the Constitution. So Article 141 of the Constitution says any judgment which is passed by the Supreme Court is binding upon all the other courts. Any judgment that is passed by the High Court is not binding upon another High Court. A judgment passed by a High Court may have a persuasive effect on another High Court, but not a binding effect. A judgment passed by High Court will have a binding effect on all the other subordinate courts in that particular state, but not on the other High Court. But the judgment which is passed by the Supreme Court will be having a binding effect on all the other courts in the territory of India. So this is basically what you'll have to understand. And now we have got what is called as a rule making power. So what does it mean by the rule making power under Article 145 of the Constitution? A rule making power under Article 145 of the Constitution allows the Supreme Court of India to make rules. And what are the rules they can make? They can make rules related to how the cases shall be filed in the Supreme Court. They shall make rules as to how the cases shall be listed in the court. They can make rules as to what shall be the conduct of lawyers. They can make rules with regard to who can be considered to be advocate on records. They can make rules with regard to fees that shall be collected during filing of cases. So with regard to all those things, they can make rules in order to ensure the smooth administration of justice. But however, try to understand, whenever the rule is made by the Supreme Court, this is very important, that the rule made by the Supreme Court under Article 145 of the Constitution could not go beyond what is the scope of the Constitution. Therefore, the rule shall not be violative of what is mentioned in the Constitution of India. So these are all the basic understanding you should have with regard to the Supreme Court. Apart from that, the Supreme Court of India also has got what is called as review powers, which we already discussed. What is this review powers? Review powers are the powers which is given to the Supreme Court under Article 137 of the Constitution, where they can review their own orders and judgments. Suppose if certain orders are passed by the Supreme Court and they feel that there is an error in that particular order or there is some mistake in that particular order, those orders may be again reviewed by the Supreme Court and they can change this order. Suppose even after the review powers are over, if the mistake still persists, so for the first time after the order is passed, they can have a review power. So even then the mistake persists, then a curative, they also have what is called as curative powers, where a curative petition can be filed. Under the review powers, review petition can be filed by the affected party. Based on the curative powers, curative petitions can be filed by the affected parties. So the curative power or the curative petition is filed once they have exhausted their review petition or the review powers. and then also the mistakes can be rectified by the Supreme Court. So these two powers are exercised by the Supreme Court under Article 137 of the Constitution. However, if you read Article 137, it explicitly mentions only the review powers. It is only the Supreme Court of India said that Article 137 not only gives the review powers but also the curative powers to the Supreme Court. It is only the Supreme Court which has got the review powers directly under the Constitution. The high courts may also have review powers, but they don't directly derive this power from the Constitution of India. All right. So these are all the important powers that you'll have to keep in your mind with regard to the Supreme Court of India. Very, very important. Try to remember all those things. Now we are almost coming to the end of the discussion. So please come here. The power of the Supreme Court of India to decide disputes between the center and the state falls under what? If there is any dispute between the center and the states, it falls under which jurisdiction? Advisory, appellate, original, writ jurisdiction. Very simple question, but such questions are asked in UPSC examination. If you watch my lecture, it is not very difficult for you to answer this particular question. So please put your answers in the comment box. If you like this particular video, please share it with your friends and others who are preparing for the competitive examination, and I'm sure that it is going to be extremely beneficial to the students preparing for the examination. If you have any queries, you can reach out to me through my Instagram account or through my Telegram channel, and you can also reach out to me at any time with regard to any preparation doubts. You can consider me as your friend, mentor, guide, but however, don't hesitate to reach out to me. Thank you very much for watching this particular lecture. All the very best.